there is, and we found it. We're going to show you what Florida's risk pool information looks like. And we took it to two different levels. One, they have a $200,000 to $300,000 limit on certain offenses. But when it comes to violation of civil rights under 42 U.S.C. 1983, the risk pool, cha-ching, 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 is unlimited as to the amount of damage money you can collect. And that includes treble damages, punitive.
Really? Oh.
High, running from the rolling thunder, hard comes the rain.
Welcome to Deed Thieves, Stolen Homes, Dirty Hands. I'm Maya with the Homeowners Grassroots Coalition Against Deed Theft. Your guide through a world where homes are stolen with the stroke of a pen, the courts rubber stamp fraud, forged signatures, fake notaries. This is America's quietest crime wave, deed theft. Who's profiting? How deep does the corruption go? And can it be stopped? Let's dig in. Today's guest is Dave Kreiger. Dave is an award-winning former radio host, anchor, and investigative journalist recognized by the Associated Press broadcasters. Since the 1990s, he's focused on real estate, foreclosure, and consumer credit law, publishing the Credit Restoration Primer and the highly regarded Clouded Titles Mayday Edition. Dave teaches continuing legal education courses on foreclosure defense and quiet title actions. Welcome, Dave. I'm so happy you could join me today.
You bet, Maya. Appreciate it.
So, this seminar you have coming up, it sounds so exciting. October 18th, 19th in Orlando, Florida. So, do you want to just jump in and just tell us a little bit about that?
I will. I will first off by telling everybody that if you show up at this class, you'll get to see Maya there because she's coming too.
Yes.
So if you want to meet the face behind the voice and the picture on the screen, she'll be there, like so many other people. We have actually had some interest from judges who have been foreclosed on, attorneys who have been foreclosed on, as well as homeowners. And of course, I missed default by one day, and I did strategic default as well, which I write about in the book Clouded Titles. But the thing is people are going, oh God, another Kreiger seminar. Well, this is different. We have all new information to share. About 85% of this particular workshop that's held at the Homewood Suites by Hilton Orlando Airport. The beauty of it is you can fly right into MCO, which is the airport code for Orlando. And they have a shuttle that runs 24/7 that will pick you up and bring you right to the hotel. And if you call them at their number, and if you are interested, you can email me through the KreigerFiles.com website, because that is my current nationally syndicated talk show. It's called theKreigerFiles.com. And if you want to email me through that, I'll send you, if you give me your email address, the flyer and registration form, because right now we are 1/3 full. The cutoff date for sleeping rooms is October 3rd. And if you haven't made arrangements yet, this is going to be really interesting because, one, we have the FDCPA debt collection and foreclosure book that you're going to get. And I also, right here in my hot little hand, right here you can see them in this Ziploc bag. These are 64 gigabyte flash drives, and I've got 30 of them in here. And that means everybody gets one, and they're half full, which means you have room to store all your case files and all your research on the same flash drive if you don't have a lot of space in your laptop. And the beauty of this workshop is you get to bring your laptop. We'll have plenty of power strips and plugins to where you can keep your laptop charged, and you can actually, follow the bouncing ball as we bring this up on the screen. The beauty of this is that we call it Foreclosure Wars 2.0. And there's a difference between what we used to call it, which was foreclosure defense, and what it has become, which is a war in our courts, because we have discovered through hook or by crook that these judges are just that. They help the banks win their case, They give them tutoring from the bench. They ask questions from the bench and they prosecute the case. And these are things that, homeowners just frankly don't understand when they get into court. And what they really don't understand is what private investigator Bill Pataalo from Whitefish, Montana, he's licensed in Oregon as a private investigator. He has fought 3 different foreclosure cases. I have seen him testify in court in Florida. And he has agreed to come out and teach us his new patented process, which is administrative in nature. And you get to actually see all this stuff live. And then Bill's going to take each one of the 30 attendees into his class, into his suite, and counsel you on his program and what it means and what he can do specifically for your case. Now, you're not going to get that kind of tutelage anywhere else. Bill is currently helping clients, some of which are actually registered and coming to the class now. And they've got some interesting stories to share. We have foreclosures that are still in progress. We have some homes that have been sold, and the third-party buyer does not know that he's involved in a lawsuit yet, but he will. We are suing judges now. And when I say me or we, I refer to, and we're not giving legal advice here because we can't do that on the show. We have people that call up and they say, Dave, what should I do? And it's like, wrong question. And you're saying, why is the wrong question? Well, because when you say, what should I do? It's like, now you're asking me to give you some sort of what could be interpreted as legal advice. I can't do that. But if you rephrase it properly, then I'll answer your question. Okay, Dave, if you were me, what would you do? Good question. I would file a debt relief action. And I would assert that the wrong party get paid because in 99.9% of all foreclosure cases out there, the wrong party's getting paid. And there will be some people that will argue with me and go, no, Dave, it's 100%. Well, some of these, the other 0.1%, are basically portfolio loans. These are lenders who actually kept the paper, put it in the vault, you borrowed it, you know where your loan is. And so when you're dealing with these people, you are actually dealing with the entity that loaned you the money, supposedly. But you're going to find out some other truths in this class because Bill Pataalo is going to be sharing a patented process with venture capital backing behind it. And he's actually in the process of helping homeowners recover damage money. And this is something that, he will share in the class as far as the how to get into that plan and move forward so that you can potentially get yourself in a position to demand money. Now, you ask, why are people suing judges? Well, every state is a risk pool, and we're going to be sharing that information with you in the class. Now, risk pools, if you look, every state has them. Every state requires under their government code that judges be bonded or they are covered under government code in the risk pool, which is run by the state. And see, not many people know about this. This is like when you sue an attorney, which we are a lot of, and this is the one thing. People are afraid to sue the attorney because they're afraid, oh, well, this isn't proper and the attorney's lying and we know the attorney's lying. And I'm like, okay, we don't need to worry about the attorney lying. See, if we can catch him in the act and he's claiming that we're in default when we know damn well we're not, and we can show and flip the narrative and flip the script on him. See, people just need to learn to do that, and that is what we're teaching in this class. So this is happening, like I said, as you mentioned, Maya. This is Saturday and Sunday, October 18th and 19th from 8:30 to 5:30 both days. We're going to have Q&A sessions. We will be videotaping this event for posterior's sake. And posterity, I'm just being facetious here. But the thing is that if you come, you're going to get the flash drive. That's worth the price of admission. And in addition to that, because this has 37,750 plus files on it, including all the slides in various formats from this workshop. And in addition to that, you're going to get a copy of the FDCPA book, and as an added extra bonus, for those of you who are looking on the screen up behind me right here, I'm going to reach up and pull out what I'm going to throw in as a sweetener for those listening to the show. This is the Credit Restoration Primer. Let me hold it back here so you can see it. This teaches you how to clean up your credit using the same formulas I use. I'm going to throw that in as an added extra bonus for you so you can get yourself up and running again.
Wow.
I've gotten rid of bankruptcies. I've gotten rid of foreclosures. I've gotten rid of child support. I've made phone calls to attorneys and threatened them, told their clients, I got case law here that says your client paid off like a slot machine. And when they say, what do you want? I want you to take that trade line item off my credit report. And they make a phone call, done. So
wow.
I'm telling you, there's all sorts of very useful information here. The problem is that people are just, they're scared about going to court. And we're going to teach you some alternative ways so you don't have to go to court. Eventually, if it gets that dicey, you might. But those of you who are currently engaged in foreclosure, we're actually going to change the narrative and show you how to use various strategies to go in and beat up on the lawyers that are coming after you, because they're not representing the lender. They're representing the mortgage loan servicer. And if you look at your deed of trust or mortgage, you'll see what I mean if you look at paragraph 19 or 20, depending on which long form mortgage form you have. So this is one of the reasons why we decided to bring this in. And, just understand that you get free Wi-Fi, in-room kitchen, pet-friendly connecting rooms, 24-hour airport shuttle, digital keys, outdoor pools. And you got Disney World if you want to come hang out and spend some time at the theme park, you can do it. And the flyer that I will send you has the registration form on it. The most important thing is you get that back to me and get signed up and reserve your room by October 3rd, because unless you call me and tell me, hey, they ran out of rooms, which we may already have, you're going to have to tell me I need to call the hotel and extend the room block so you can get in there at a special rate. So this is basically what we're talking about. Maya, you have another question.
Well, I hear you saying things like flip the script on the banks, and maybe give a little preview of what exactly one little maybe path to do that.
Okay, let's talk about flipping the script. The collapse of the American housing market in 2008, okay? I know you're all familiar with that. It wasn't just a financial crisis. It was the inevitable consequence of a silent structural shift triggered by the repeal of the Glass-Steagall Act and the unchecked expansion of mortgage securitization. What most people don't realize is that the same mechanics that caused that collapse are still operating today, and worse, they've rendered our traditional consumer protection statutes like TILA, RESPA, the Fair Credit Reporting Act, the Fair Debt Collection Practices Act, largely obsolete. But these laws were designed for a system in which identifiable lenders extended real credit. But today, through accounting sleight of hand and derecognition schemes, there's often no true creditor on the other side of the table. Borrowers unknowingly funded their own loans, while servicers and phantom trusts enforce obligations they have no lawful right to collect on. So the presentation we're talking about here, as far as flipping the script, is going to reveal what we know. What we now know, that we haven't been teaching in other classes, because the narrative always was, how do we defend our house? Now we're calling this Foreclosure Wars 2.0, Maya, because homeowners were never actually borrowers in the conventional sense. They were unwitting creditors whose signatures created securities that were monetized and sold without disclosure into a global debt market. Now, we have been talking about this in guerrilla litigation strategies when I held my last class last year in Little Rock. And the thing is that if you read this publication, Modern Money Mechanics, as the Federal Reserve acknowledged, what happens is that banks do not lend existing money. They create deposits through the borrower's promise to repay, and in reality, no actual loan occurred. Now, I know this may be really hard to swallow. The homeowner's note was the asset. The so-called lender simply booked it as a liability and monetized it on Wall Street and in all these private REMIC trusts without disclosing the true source of the funds. So flipping the script is being able to turn the tables on the narrative. It's about educating homeowners, attorneys, advocates on how to understand the true nature of the transaction and how to use a powerful administrative process to reclaim control. So what you're going to learn in the class on flipping the script is how to, A, challenge the presumptions of debt. See, because if you go into court and you don't know how to argue this stuff, if you're still fighting in the court, And you can't argue this. If you don't have the knowledge, you're going to lose. You have to demand proper disclosure. And so many people they like, oh, I'm going to file a counterclaim, then I'm just going to sit on my laurels and wait and see what happens. Nope, sorry, you can't do that. Things have changed now. In order to get proper disclosure, you have to know how to effectuate discovery, and we're going to be teaching that in this class as well. You've got to shift the standing back to the so-called lender and record enforceable defaults into the land records. Now, I have advised people in the past, do not taint the land records with anything. You know, I've had people go out, Maya, and they've done some crazy things, like they will record a deed of reconveyance or a satisfaction of mortgage in their own name. And they will record it like the loan's been forgiven. Well, they don't have the authority to do that. They have a contract that they signed with a lender, and they don't have the authority. But see, what they don't understand is the lender didn't give them any money. And these are things that we're teaching, because people are like looking at this going, what? They don't get it. They're totally confused when they go into court and the judge starts prosecuting the case from the bench, and we're teaching all those little tricks. He starts prosecuting and asking you questions like, are you in default? When's the last time you made your mortgage payment? And you're just like, oh, man. And what do? Most homeowners sit there and go, I don't know.
Well,
they don't have the right answer. See, and this has been the problem, and this is part of flipping the script, is one, being able to answer that judge appropriately and changing the narrative right out from under the attorney. And see, what the attorneys are not expecting is that you're going to turn around as part of your counterclaim and you're going to sue the attorney. And we're going to teach you how to do that in the class.
Well, that really sounds great, because I know that you've mentioned those securitized trusts, because they come in as the plaintiff and they don't even exist. And so it really is such a confusing, total sham. But what do you do in that case? Like you go after the attorneys when it's those fake trusts come, the securities you talked about, they're still foreclosing on people.
Sure they are. And they don't exist anymore.
No, they don't.
See, but I mean, most mortgages, the current mortgages, I see more of this as I look, because I'm helping clients all over the place.
Right.
And we're actually involved in a case in Florida where we are suing the judge because he refused to recuse himself. And so we said, okay, fine, we'll wait for the opportunity. And we did, because the client said, we are not going to be there at this hearing. I object to it happening, and you need to cancel it, reschedule.
Well,
Judge didn't do that.
Yeah. I'd like
to know. Him holding an ex parte hearing, Maya.
Yeah, wow. Whew. Well, I'd like to know why all the foreclosure judges do the same thing around the country. Somebody must have told them that, right? I mean,
yep. They're blackmailed, threatened. They're told, hey, look, see, you wonder why judges don't have their properties listed online, why they're protected, like why police officers and court officers, you can't find any evidence of their mortgages because of the fact that a lot of times the banks, in order to get the judge on their side, they will actually forgive the judge's mortgage loan. So the judge gets to live for free. I mean, we're talking about, they just want a free house. Well, we don't know. I remember a long time ago, back in 2010, there was a case out of Jacksonville, Florida, where the homeowner says, hey, Your Honor, you have a Bank of America loan. And Bank of America is the plaintiff in this case. And you can't be on the bench because you have a conflict of interest. The judge refused to recuse himself. And that was a Countrywide versus Mines case. So for those of you who know, he took it all the way to the Supreme Court of the state of Florida. He did all the administrative processes right. And after all was said and done, the judge had to recuse himself by order of the Supreme Court of the state of Florida because it did, in fact, represent a conflict of interest. Now, if you're going to hold a foreclosure judge accountable, then we have to catch him in the act of prosecuting the case, holding ex parte hearings, educating the other side's attorney as to what kind of filings he needs to put forward. And I mean, I've seen this in federal court where they actually, the magistrate stood there and told the attorney for the bank or this phony third-party junk debt pool how to word his pleading. Yeah. You cannot do that. That right there is enough to get that judge impeached if you were smart enough to recognize But see, part of the problem is that attorneys, they get so scared because they're going to lose their bar card that they fail to object. They just let this thing go on. And when the judge said, I mean, I've seen attorneys actually admit their clients were in default, and it's not incumbent on the homeowner to prove they're in default. It's incumbent on the lender or the servicer to prove that. Why would you go out there and violate your own Fifth Amendment rights and admit to stuff that you don't have any factual knowledge of?
Right. Wow. Well, I just had that thought about the judges. I've seen judges.
We're catching judges in the act of committing these things, and you have to prosecute them. I will tell you this much. I don't want to let all the cat out of the bag, because there are things, when people hear this, they're going to go, oh, Kreiger gave me enough. I don't have to go to the class. No, wrong.
Yeah.
You need to be able to explain the narrative and understand exactly what's going on before you go into court, if you have to. But see, what happened was the opportunity came up to where we could catch the judge, and it was a Zoom call. And see, Zoom calls are very unfair, because that judge, it's his court, and he's got complete control of the microphone, and everybody thinks, oh, these Zoom calls are harmless. Well, see, the judge can shut you off.
Yep.
And so what we do is you have, and this is the case where we caught this judge, and he was doing this ex parte hearing, and we had a court reporter actually log on to the Zoom call and transcribe the entire hearing into 30 pages. And when the lead attorney that called for the hearing, knowing that it was objected to, and allowed it to go forward, and the judge wouldn't let anybody but the attorney speak, and the plaintiff wasn't there, that's what we call an ex parte hearing, and that's in violation of the Judicial Code of Canons. So every state's got them, and so does the ABA.
Yeah. I've seen judges come in with case law to override the defendant. I mean, actually cases under their arm, bringing him in.
What are they doing? What are they doing? They're prosecuting the case, Maya.
I know.
When the judge comes in and he starts talking and he starts doing case citations, what's he telling the other side's counsel? Here's how you win. So, if you don't stand up and object to this stuff, this is why I don't like Zoom calls, because the judge is like, you'll get your turn. Objection, Your Honor. And all of a sudden, we have a dead microphone.
They don't allow that.
They don't allow objection. But right there, that judge has violated your due process rights under the Fifth Amendment to the Constitution of the United States, whether he is in an administrative proceeding or not. Because, see, we're talking about contract law here. Yeah. Contracts, and people go, well, contract, what's the Constitution? Article 1, Section 10, Clause 1. The obligation of a contract shall not be impaired. But fraud vitiates all contracts. So if you can flip the script on the narrative, and you catch this judge in the act, and this judge is being paid for by the county, and you are telling this judge, first off, as soon as I get a chance, Your Honor, I've objected to this. You're making a record. You're not allowing me to object and make a record. I have nothing to take to the appellate court. And so it literally, these judges are defeating your opportunity to appeal the case deliberately. And they're siding with the bank by shutting you off so you can't make a record. Now, you got the judge dead to right on a Zoom call if you have it transcribed, but you have to have a court reporter go on the Zoom call and log in and transcribe everything, so that when you do get on and you do make a record and you object to what the judge has done and you call them out and you say, you have given the other side a whole bunch of different case law so that he can win his case. You're prosecuting the case from the bench. I'm sorry, Your Honor, but that's unethical. What you just did right now is the appearance of bias and prejudice, and it's in violation of the judicial canons from our state code as well as the ABA. And so, you can't say, take it back. It's too late. You just have to be able to object. See, when they don't let you make a record, it's a violation of due process. That's enough to sue a judge over. Because if he keeps on doing this and he tells you, you shut the F up and I'll tell you when you can talk. Right there, he's prevented you from making a record.
Right,
and if you're on a Zoom call, you can sit there and hold up a sign saying objection. Because see,
that's a good idea.
They can see you, but they can't hear you. But you at least hold the sign up that says objection.
I'm going to do that.
And the judge literally, what are they going to do? Your Honor is prosecuting the case from the bench. Objection. Have cue cards, hold up cue cards of the various things that judges do. Because see, what constitutes an ex parte hearing? An ex parte hearing is where the plaintiff or the homeowner is not allowed to participate or is barred from participating, or the hearing is held outside the confines of the homeowner. So this judge is violating all sorts of judicial canons. But you have to use the administrative process, which we teach in the class, to take this all the way up the ladder. And we're actually going to give you the ammo that other people have used to do this. So, like I'm saying, people, if you're at a loss for words now, just wait till you get to the class.
Okay.
We're gonna supply you with the notepad, a legal pad, a pen you can write with, the books, the flash drive. You bring your laptop, you can plug your thing in there, the flash drive in there, and you can actually dial into the class right there. We're going to show you how the flash drive, there's 37,750 plus files on this flash drive, which it's like 2007 forward of legal research and case law.
Wow.
Judicial misconduct, attorney misconduct. Not to mention all the litigation we put in there.
Jeez, Dave, hearing you is such an inspiration, because I love the cue card thing. I'm going to do that.
Yes, I just let the cat out of the bag. See, that's why I don't like Zoom calls. Seriously, if the judge is looking at you and you're sitting there in shock, just hold up a card that says objection.
I know.
Objection, counsel's testifying. There's so many things. You can sue the attorney because the attorney is not representing who they say they're representing.
Love this.
They're lying to the judge.
God.
This is why you can sue them. They're committing perjury in the court.
Absolutely. Absolutely. They just, yeah. Oh my God. So, wow.
That's not legal advice. It's just common sense according to your rights.
Exactly.
If you don't know your rights, you don't have any.
Exactly. Oh my gosh, Dave. Whew. Jeez, I'm not even sure where to go from here. So, talk a little bit about Bill Pataalo. He's doing this new thing that keeps people out of court. This is just amazing. Want to talk a little bit?
This is a patented process. And when he first called me, now understand something, out of nowhere, I got a phone call from Bill Pataalo. He's a private investigator licensed in Oregon, lives in Whitefish, Montana. I have seen Bill testify in court in Florida. I watched how both attorneys were reacting, because that's what trial consultants do. And I have been to trials. I've been to Rocket Docket in Miami-Dade. I've seen all but 2 homeowners lose their homes on the spot. I've seen judges scold old grandmas that are sitting there bawling, "You got 3 days to move out, honey."
Right.
They're just like freaking out.
Oh, yeah.
I'm just like, my God. And my wife and I are standing there with this attorney who's a dear friend of ours. He's passed away since, he just literally gave up. He says, every time I walk into court, it's like some attorneys I know that say, this judge just stuck his size 9 shoe up where the sun never shines. You want to see? And so, it's like the attorneys are afraid because they work too hard to get through law school, to learn procedure, to learn rules of evidence. Homeowners, man, when you get served with foreclosure notices, you're like, what do we do next?
Right. A deer in headlights. Yeah.
Deer in headlight look. Yeah. And you're just like freaking out going, look what they're saying. I got this complaint served on me. Or
yeah.
I got this notice from I'm in a deed of trust state and they're going to sell my house on the courthouse steps. What do I do?
Mm-hmm.
And see, this is one of the reasons why the whole idea behind flipping the script and the narrative is understanding what position you are in. And so, I've written about this on my blog, and I'm going to give you the name of the Substack page. Because Clouded Title's blog does not have all of the stuff on there. I've been going to Substack now, and it's davekreiger.substack.com. So if you go there, I post a lot of different articles, and one of the things I talked about was your loan application. And I'll reiterate, this is where Bill is going with this, how your mortgage became a Wall Street security. I explained that because what the originating lender, who's a table-funded lender, didn't tell you. And they call it table funded because there's an interim funding lender under the table. And Lord only knows what he's doing to the originating lender. Right,
yeah.
I'm happy. Look at this. I'm really charged up now, man. And you're looking down going, what's going on under there, Your Honor, how are you dressed under those robes, Your Honor? See, all this stuff gets exposed, and we teach this stuff because, see, here's the thing. when you go to the table and they hand you this Form 1003, it says Fannie Mae, Freddie Mac, mortgage instrument with MERS. And what Bill told me when he called me was, this patented process I have reverses the entire MERS process.
Oh my God, that is incredible. That is so incredible, Dave.
So
oh
now
my God.
When you look into this, you have to understand that the table-funded lender, the interim lender, was working with the servicer of your loan who was already in bed with them, right? Mm-hmm. When you brought in your loan app all filled out, you had your 1099s and your
right.
all your income statements and everything they gave you. Give me this big long list of what your capabilities are, how much money you make, and where's your child support, and you have, alimony or whatever it is. Lay all the cards out on the table. We're going to take all that stuff and we're going to create a data set out of it, out of your loan app, all your documents, your credit history, your credit scores. All of this is, we're going to sit there and we're going to evaluate and go, yeah, we can make them a loan. And, hey, you want to buy a nicer house? Let's put a 0 after your income there. And instead of $1,200 a month, it's $12,000 a month, and we'll get you into a mansion. So this is what they did way back when. Well, so what happens is this is what they've taken, and they've securitized the paper. As soon as you walk out the door, the servicer is already on Wall Street. He goes into the MERS system. He creates a file. He gets assigned an 18-digit MERS MIN number. And I remember the days when I went into court in Kansas City in a federal settlement conference. I was invited there by the judge, believe it or not. And MERS's attorney tried to have me thrown out. Man, he was screaming bloody murder, and I knew at that point I had a target on my back. Because I had just come out with clouded titles, and he's sitting there screaming, he wrote a book, he's got a blog, he's on the radio, he's got a website, oh my God, he can't be here, this is a private settlement conference. Judge said, I invited him, he stays. And so when I get sequestered in the jury room, the judge says, hey, well, he walks in, I shake his hand, good morning, Your Honor. He says, what is it you do? He wanted to know why MERS's attorney was getting all bent out of shape. I said, well, it's probably because of this book. And I handed it to him, and he looked at the cover of the first edition of Clouded Titles, and I wrote in 2010, and just this ear-to-ear grin started to turn into a chuckle. He had to contain himself.
Oh my God!
These judges know. It's just that nobody's presenting the evidence the way it needs to be presented, which is why homeowners are losing. And their attorneys don't know much better, which is why we're inviting attorneys, even disbarred attorneys. I've had disbarred attorneys call me and say, I want to come to your class.
Good,
because, how are they going to make a living?
Exactly.
They can help homeowners through the administrative process because they've already got the law, they've already got the knowledge, and if they want to be a ghostwriter, there's money on the table.
Yeah.
So, why should we deprive them if they know the law and they can counsel, the homeowners? Why not? Pro se doesn't have to worry about losing their bar card.
No.
Attorneys do, which is why they sit there and they walk on eggshells and tiptoe around in court. They won't object when they're supposed to. They don't call the judge out. I've only known one attorney that says, I'm glad I'm not litigating against you this afternoon, Your Honor. And it looks to kill that attorney had been done on the floor because he felt the judge helping the bank. And this is in Miami-Dade. I was standing right there watching it. I saw the look on the judge's face, man. She was caught dead to right.
Yeah. Well, they ignore all evidence from homeowners, and that's what's so discouraging because that's due process, right? To ignore your evidence?
Well, part of the problem is they use procedure against you.
Totally.
Yeah, when you walk in, everybody gets out procedure. And if you have judges come to this class, which there's been indication that there will be a judge that got foreclosed on.
Yeah.
When you come in front of a judge, the judge has the same narrative affixed in his brain, and you're on a mission to educate that judge no matter what. And so pro se litigants, if you don't understand rules of civil procedure and rules of evidence, and you don't understand state court rules and local court rules,
which is a lot,
you don't know how to keep your case out of federal court, because in federal court it's limited jurisdiction, you're going to get creamed. Because these federal judges do not have the time, the tolerance, or the patience to deal with pro se litigants. They just don't.
Yeah.
And attorneys will out-procedure you dead to rights in federal court. And so the whole idea is, unless there's a reason why you have to be in federal court, stay out of there. And we're going to share all this information with you in the class.
Wow. Oh my gosh. This just sounds so exciting, Dave. I can't wait. So much. Wow. So the 20 million property owners who've lost their houses since 2008. Is there any way of restitution for that? That's the risk. That's your risk management, and they can go back that far, perhaps?
That's a big question. That's a Bill Pataalo question. And I would say that, if you ask them that at the class, you'll get an answer. Because, see, all these states like to argue that there's a statute of limitations. And, 5 years for fraud and all this, and people have lost their home. There's one exception to the rule. And I have a guy coming from California who I just got off the phone with before we went on here.
Okay.
And he just got a check from Wells Fargo.
Uh-huh.
And they sent him a check for $500 with a letter of apology saying they made a mistake in his escrow. Now, he's been foreclosed on for 9 years now, and his house is worth almost $1 million now. We're talking about California property here.
Right.
He's lost his home. I mean, he almost lost his marriage because of this. See, because that's what these foreclosures do. They break up family units.
I know.
So because of the fact that they've sent this letter out, they've all of a sudden moved the case forward and opened up a can of worms because they just admitted to a mistake. And so the question I asked is, what other mistakes have they made?
Oh,
and see, now we can bring it up because they've moved the case forward by sending him this letter. And so now this fraud, what mistake did you make? See, that's where deck relief comes in, and we teach you all the fundamentals of declaratory relief.
Wow.
Because once you understand how deck relief works, you get discovery. And see, you've got to know how to play that game. And see, through subpoena ducis tecum, we've got the Florida Attorney General and their minions dead to right because they refused service on a subpoena ducis tecum. And now we're moving for sanctions against the Attorney General of the state of Florida.
That
now
is
imagine
huge.
That, because see, now that right there, you have to understand about the complexity of all of this and how it equates to the risk pool.
Yeah.
The state, I mean, even the Florida Sheriff's Association, they admit they have their own risk pool in case the sheriffs screw up and they cause harm. They rip somebody off. Well, if the courts who are being paid and have an account vested with the state for their retirement fund, okay, see, if they're acting on behalf of the bank and they're committing all sorts of procedural errors and basically what we call judicial misconduct, and they allow the attorneys to commit attorney misconduct, and then you sue the judge, and it's automatic. The Attorney General of that state, wherever you're in, is going to come in and they're going to file an action. They're going to file a notice of appearance, and they're going to step in to defend the judge. Why? Because the judge is an official of the state.
Yep.
Whether it's the circuit, the superior court, the district court, it doesn't matter. But the thing is the risk pool is tied to the judicial behavior of that judge. And see, with attorneys, it's errors and omissions insurance. And if the attorney loses the ability to get E&O, he can't practice law.
Wow.
Because he's got to be insured to protect against harm against other people. Well, the state risk pool is a big money pot, at least we think it is. When you tap into the risk pool, and people have, that's why they have it. There is, and we found it, we're going to show you what Florida's risk pool information looks like, and we took it to two different levels. One, they have a $200,000 to $300,000 limit on certain offenses, but when it comes to violation of civil rights under 42 U.S.C. 1983, the risk pool, cha-ching, 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 is unlimited as to the amount of damage money you can collect. And that includes treble damages, punitive.
Really? Oh, God, I'm excited.
So I mean, this is what we're teaching. This is stuff you did not learn in any other foreclosure defense workshop.
Right.
85% of this stuff is brand new out of the gate, and the other 15% is all, I've heard this before. I've heard that before. No, it's upgrades and updates from the previous stuff we used to teach.
Okay.
So now, for all fundamental purposes, intensive purposes, it's all new stuff.
Speechless. My goodness,
The
Dave.
dynamic has changed, Maya.
I know that. Oh, wow. Whew. Well, this has been incredible spending this time with you, Dave. Final thoughts for our audience. Final thoughts. What to help? What can you say to help people maybe just getting that lawsuit in the mail today, or at the door, knock on the door? What final thoughts for anybody going through this mess? I call it the scheme.
Yeah. Yeah, I know. The scheme.
The scheme. I call it the scheme.
That's a fair statement. The thing is understand first off, who is foreclosing against you? These third-party junk debt pools, we seem to see a lot of them these days, and we'll be talking about them because the judges are getting fooled by them. And we've got one judge down in South Florida that got fooled by it. And she declared that the plaintiff got paid. And what happened was they reversed a quiet title judgment. And then the bank came in, according to their attorneys, and it was this lender, this New Res Mortgage Loan Trust. And if you've seen one of these things, and they've got a fairly recent date like 2016, 2017, 2018, whatever. These are junk debt pools. They have no EIN number. They have no way to cash any of this stuff in. And I'm going to show you what investment source in this class you can go to find out who's really behind the eight ball.
Really?
Because it's the servicer. And that, I mean, if the REMIC is closed, they're not getting any money. And we're going to show you documents that we have uncovered that say and prove that the REMIC's got nothing and the servicer's got everything.
Wow.
And so, first off, understand who your enemy is.
Yeah.
That's number one.
Yeah.
You know, as far as, if you're facing foreclosure, it's not the lender that's foreclosing on you, it's the servicer. But the party plaintiff is not the servicer. Unless you see Nation Star or Rushmore or New Red Shell Point or any of these others, Fay Servicing, unless you see them there, it's why are they there? I didn't have a contract with them. But
I know.
You have to understand the servicer is a debt collector.
Part of the scheme.
When you throw out the FDCPA, what do? Remove it to federal court. And if it's older than 1 year, you've already exceeded the statute of limitations and they throw your case out. Wasted time and money.
Yeah.
This is why we have state debt collection laws.
Yeah.
Because when you cite state debt collection laws, you keep it in state court. So don't ask federal questions. These are other things that we teach you in the class. So, just, grow a pair, get to the class, and understand exactly if you still are in the middle of foreclosure or you just lost your home, it's not game over. And we're going to show you why that is in the class. You actually have a way, and you may not be able to recover your house in certain circumstances, but there may be a way to recover damages. And of course, certainly the one thing we want to do is we want to catch your judge in the act. We want to catch the attorneys in the act, and we want to attack the state risk pools. That's what we want to see happen. Because till that happens, the state is going to continue to allow these judges to run roughshod over homeowners. Absolutely.
And I love everything you're talking about, Dave. Whew. Well, this has been just so incredible, and I'm anxious to get going with your stuff. So let's just say,
you can't tell I'm
to everyone
about this at all, can you?
Dave, you are just so incredible, and you know what? Your passion is what's the word, like? It goes out and it spreads, and that's wonderful. So,
well, you know what? I'm motivated by the Spirit. And when I speak from the Spirit. And the Spirit motivates me to help other people. And the reason I'm on this earth is to bless other people's lives, no matter what they think.
Wonderful, wonderful. Well, we homeowners just wanted justice. That's all we ever wanted. And we just didn't get it. So those of us who keep at it just go, hey, where is it? Okay, so let me say to our audience, if you or someone you know has been affected by deed theft, we want to hear from you. Email us at deedtheft@gmail.com. So stay alert, protect your property, and remember, not all thieves wear masks. And the links below will have the brochures of the seminar and other links to other things that might interest you.
And we appreciate you and your time and all the effort that you're spending in this too as well, Maya.
Thank you, Dave.
Get the word out.
High, running from the rolling thunder, hard comes the rain.